concept of natural law, or jus naturale, occupies a central place in Roman legal thought and philosophy. Emerging from both Greek philosophical traditions and the practical demands of Roman law, natural law provided a framework through which Romans sought to reconcile justice, morality, and human conduct. Its development was gradual, shaped by early legal codifications, the Stoic philosophers' teachings, and the practical experience of administering a vast multicultural empire. Understanding natural law in Roman philosophy requires examining its origins, philosophical foundations, relationship with human law, and long-lasting influence on legal and ethical thought. Origins and conceptual foundations. The idea of law inherent in nature can be traced back to early Roman and Greek intellectual traditions. In Roman law, natural law, jus naturale, was distinguished from civil law, ius civile, which was the law enacted by the Roman state and applied to Roman citizens. Whereas civil law could vary according to political and social circumstances, natural law was seen as universal and immutable, reflecting the rational order of the cosmos. Cicero, a prominent Roman statesman and philosopher, emphasized that natural law was not a human invention, but a manifestation of reason inherent in all people. In his treatise De Legibus on the laws, Cicero argued that true law is right reason in agreement with nature. It is of universal application, unchanging and everlasting. Cicero, De Legibus 3.9. Cicero's interpretation of natural law was profoundly influenced by Stoic philosophy, which held that the universe is governed by a rational principle, or logos. The Stoics believed that human beings, as rational creatures, possess the capacity to discern this universal order through reason. Hence, natural law was perceived not merely as a set of moral precepts, but as the rational foundation underlying justice, equity, and human conduct. This alignment of human reason with cosmic reason formed the philosophical backbone of Roman ideas about natural law. Stoicism and Roman natural law. Stoicism, particularly as interpreted by Roman thinkers such as Seneca and Marcus Aurelius, deeply shaped Roman legal philosophy. Stoic natural law posited that justice was not merely a social convention, but a reflection of a universal moral order. Seneca, in his letters and treatises, frequently argued that moral duties arise from the inherent rationality shared by all humans, independent of political authority or local custom. Marcus Aurelius, in Meditations, echoed this sentiment, emphasizing that human beings are obligated to act in accordance with reason and the natural order. This philosophical underpinning influenced the practical administration of Roman justice. Roman jurists like Gaius and Ulpian acknowledged natural law as a higher standard to guide interpretation and application of civil law. They recognized that while civil law addressed specific local needs, natural law provided a universal measure against which the fairness and justice of any legal rule could be evaluated. Ulpian, in the Digest of Justinian, famously asserted, "What is natural is always just to all, and not unjust to anyone." Digesta 1.1. This maxim reinforced the idea that natural law transcends temporal and spatial boundaries, embodying principles that apply to all human beings, regardless of social or political status. Natural law versus human law. A key aspect of Roman thought on natural law was its relationship to human law, our jus gentium. While natural law represented universal moral truths, human law was contingent, specific to Roman citizens, and enforced by political authorities. Roman jurists frequently discussed how civil laws should be informed by natural law principles to ensure justice. For example, unjust laws, those in conflict with natural law, were not considered true law in the moral sense. Cicero maintained that an unjust law is no law at all, emphasizing the moral dimension of legality. The Romans also developed the concept of ius gentium, the law of nations, which functioned as an intermediary between civil law and natural law. Ius gentium was applicable to foreigners and dealt with practical matters like contracts, trade, and property. Its significance lies in its reflection of natural law principles, fairness, reciprocity, and universal human reason. By incorporating Stoic ideas, Roman legal thinkers sought to create a body of law that could operate across diverse cultures while maintaining a core ethical foundation. Practical implications in Roman law. In practice, natural law influenced several key areas of Roman legal thought. In contract law, principles of fairness and good faith were rooted in the understanding that agreements must reflect moral reason, not merely procedural compliance. In criminal and civil matters, jurists used natural law to interpret statutes in ways that harmonized with ethical standards. Concepts like equity, equitas, the adjustment of strict legal rules to achieve fairness, stem directly from the recognition that law must conform to the broader moral order. Natural law also shaped Roman ideas about justice in governance and punishment. The Stoic notion of universal reason implied that rulers, magistrates, and judges had a moral duty to uphold justice beyond mere procedural correctness. It provided a philosophical basis for the limitation of arbitrary power and the protection of fundamental human dignity, which later influenced Roman notions of rights and the equitable treatment of subjects in the empire. Influence on later legal traditions. The Roman conception of natural law had a profound and enduring influence on Western legal thought. During the medieval period, the writings of Cicero, Ulpian, and other Roman jurists were rediscovered and integrated into canon law in the broader scholastic tradition. Thinkers such as Thomas Aquinas synthesized Stoic and Christian principles, presenting natural law as a rational foundation for moral and divine law. This intellectual lineage eventually contributed to the development of modern concepts of human rights, constitutional law, and international law. Moreover, natural law provided a philosophical justification for universal principles of justice in an era where legal systems were often fragmented and localized. Its emphasis on reason, morality, and universal applicability continues to resonate in contemporary discussions about ethics, legal interpretation, and human rights, demonstrating the lasting legacy of Roman philosophical thought. Critiques and limitations. Despite its enduring influence, Roman natural law was not without its critics. Some ancient legal thinkers questioned whether abstract moral principles could adequately guide concrete legal practice. Others noted that the universality of natural law was often invoked selectively, particularly in the context of slavery or imperial governance, revealing tensions between ideal ethical principles and social realities. Nevertheless, the conceptual rigor of Roman natural law and its integration with Stoic philosophy provided a sophisticated framework for thinking about justice, morality, and the role of law in human society. Natural law in Roman philosophy represents a remarkable fusion of moral philosophy and practical legal reasoning. Rooted in Stoic thought, emphasized by Cicero, and elaborated by Roman jurists, it established a universal standard for justice that transcended local customs and political authority. Its impact on Roman law was both theoretical and practical, guiding civil statutes, equity, and governance. Furthermore, the legacy of Roman natural law extends far beyond antiquity, influencing medieval, early modern, and contemporary legal and ethical systems. The Roman articulation of natural law demonstrates an enduring aspiration to align human society with reason, morality, and a sense of universal justice. References 1. Cicero MT, 1933, De Legibus on the Laws, Loeb Classical Library. 2. Digesta 1.1.1, Ulpian, The Digest of Justinian. 3. Finn D. 1995, Natural Law and Roman Law, Historical and Philosophical Perspectives, Routledge. 4. Buckland W.W. 1963, A Textbook of Roman Law from Augustus to Justinian, Cambridge University Press. 5. Tuck R. 1979, Natural Rights Theories, Their Origin and Development, Cambridge University Press. 6. Schiedermayer H. 2001, Cicero and the Roman Law of Nations, Oxford University Press. 7. Kelly J. M. 2002, A Short History of Western Legal Theory, Oxford University Press. 8. Watson A. 1995, The Spirit of Roman Law, University of Georgia Press.